I'm Sarah. I work in the U.S. Department of Justice Civil Rights Division. My office is called the Immigrant and Employee Rights Section, or IER. We tell workers, if you have the right to work, don't let anyone take it away. How does IER protect workers from immigration-related discrimination? Today, we'll talk about the law that my office enforces and the ways in which we can help you. We have a very helpful hotline that you can call for assistance. All the help we provide is free, and free language assistance is available. There are 4 types of employer conduct that are illegal under the law that IER enforces. Throughout today's presentation, we'll go into more detail about each of these types of illegal actions on the part of employers. The most common type of discrimination is known as unfair documentary practices, and many people are unaware that these practices are illegal. The first type of prohibited discrimination is discrimination based on citizenship status. The anti-discrimination law that IER enforces prohibits discrimination on the basis of citizenship or immigration status in hiring, firing, and recruitment or referral for a fee. The people who are protected under this particular part of the law are U.S. citizens, U.S. nationals, lawful permanent residents, and workers granted asylum or refugee status. For example, if an employer refuses to hire a person because the person has refugee status, or if an employer has a policy that limits hiring to U.S. citizens only. The law we are discussing today does not include discrimination based on the terms and conditions of employment, such as when an employer pays someone with refugee status $5 less per hour for having refugee status. However, this type of discrimination may violate other federal or state laws. Are there situations in which hiring preferences based on citizenship status are allowed? Yes. For example, when a law, regulation, executive order, or government contract requires employers to restrict hiring to U.S. citizens. However, an employer may not implement additional hiring restrictions that are not actual requirements. For example, an employer with a federal contract may not restrict hiring to U.S. citizens for all positions when under the federal contract, the restriction to U.S. citizens only applies to certain positions. In some situations under the law that IER enforces, an employer can refuse to hire certain people based on their immigration status. For example, employers may say that they do not want to hire people who require visa sponsorship. However, there are other laws, both federal and state, that may protect people from discrimination based on citizenship status. The second type of discrimination is based on national origin. This means treating certain workers differently because of the country they come from, their ancestry, their accent, or because they appear to be from a particular country. The anti-discrimination law that the IER enforces prohibits discrimination on the basis of national origin in hiring, firing, and recruitment or referral for a fee. In general, IER has jurisdiction over employers with 4 to 14 employees. The Equal Employment Opportunity Commission, or EEOC, has jurisdiction over employers with 15 or more employees. IER and EEOC have an agreement that allows agencies to refer national origin discrimination complaints to the other agency when appropriate. Call IER if you suspect discrimination based on national origin. What is national origin? Some examples of national origin indicators are English level, ancestry, clothing, country of birth, name, and accent. It doesn't matter if the employer's perception of your national origin is correct or not. Some examples of discrimination based on national origin are refusing to hire people whose first language is not English, giving hiring preference to workers from a certain country, refusing to hire someone because they have a foreign accent, even if that person can meet all the requirements of the job. The third type of discrimination we're going to cover is unfair documentary practices. This is the most common type of discrimination IER sees, and many people don't know it's illegal. Unfair documentary practices refer to discrimination based on citizenship status or national origin. Generally, unfair documentary practices occur in the Form I-9 or E-Verify processes. So what are unfair documentary practices? When completing Form I-9 or E-Verify, employers may not request different or additional documents to those already required. Employers may not reject documents that appear to be genuine, and employers may not ask for specific documents based on citizenship, immigration status, or national origin. A common example of this is an employer saying, "Oh, you're a permanent resident? I need to see your green card." Or, "Oh, you're from another country? I need to see your immigration documents." An employer should not make such requests in the Form I-9 process or in the E-Verify process. You have the right to choose what acceptable documentation you present to show that you have permission to work in the United States. Your employer will give you a Form I-9 when you start a new job. It's used to show that you have permission to work in the U.S. Sometimes the employer gives you the Form I-9 on a piece of paper, or sometimes they ask you to fill it out on a computer. The Form I-9 is administered by another federal agency, the Department of Homeland Security. The purpose of the Form I-9 is to establish the worker's identity and authorization to work. This form is not used to verify your specific immigration status. IER does not administer the Form I-9. IER investigates allegations of discrimination during the Form I-9 process. We will review each of the sections of Form I-9 and identify the parts where you might face unlawful discrimination. Instructions for the Form I-9 are available online. The Form I-9 also has lists of acceptable documents, which describe most of the documents that workers can present to establish their identity and permission to work. Employers must allow you to choose the acceptable documentation you want to present for the Form I-9. Section 1 is the part of the Form I-9 that you as a worker fill out after you have received and accepted a job offer. You fill out Section 1 of the Form I-9 after accepting a job offer and before the end of your first day of work. In Section 1 of the Form I-9, there are 4 types of options from which workers can choose. The first 3 are specific: U.S. citizen, U.S. national, and lawful permanent resident. The 4th category, non-citizen, authorized to work, includes a field for the worker to enter the expiration date of their authorization to work. Some work-authorized people have work authorization documents that have an expiration date, but their immigration status does not expire. Non-citizens authorized to work whose immigration status does not expire should write NA for not applicable in the field that requests an expiration date. The employer should not specifically ask to see an immigration document or a document with an expiration date. The slide says that workers granted asylum or refugee status are 2 examples of immigration statuses that mark NA. Note that workers are not required to present documents proving they have the immigration status they selected, because the purpose of the Form I-9 is to establish that the worker is authorized to work and not to provide proof of the specific immigration status. You do not need to provide proof of your A number or U.S.CIS number. This slide shows what is called the lists of acceptable documents that workers use for the Form I-9. The employer must provide this to you. You, the worker, choose from the lists of acceptable documents to show who you are and the fact that you are authorized to work in the United States. When you start a new job, you choose a selection from List A or a combination of documents from List B and C. Documents from List A show who I am and the fact that I'm authorized to work, such as a permanent resident card or an employment authorization document known as an EAD. Documents on List B only show who I am, such as a driver's license or state ID. List C documents only show that I have the right to work, for example, an unrestricted Social Security card. When verifying your documents, the employer cannot ask you to present a specific document. The employer cannot request more documents than are necessary. The employer cannot reject your valid and acceptable documents. And the employer's lack of familiarity with a certain document is not an excuse to reject it. Employers should call us if they have questions about what documents are acceptable for the Form I-9. Some examples of problems we see are employers asking non-citizen workers about their immigration status. An example would be asking a lawful permanent resident to present their permanent resident card instead of letting them choose which acceptable document they want to present. Employers who do not accept valid documents, such as an ID along with an unrestricted Social Security card from a worker because they appear to be from another country. Another problem is employers who reject valid documents, such as a Form I-94 with an asylum stamp, because perhaps the employer has never seen that document before and is suspicious because they know the worker was not born in the United States. That creates unlawful and discriminatory barriers to employment. Both employers and workers can call us with questions about which documents are acceptable for the Form I-9. If an employer tries to tell you what type of document you must show for the Form I-9, call us. We can discuss the ways in which IER can help you solve the problem. Call IER if you're not sure what documents you may present, or if you don't know if you have acceptable documents for the Form I-9. What happens if my document expires? If you present a type of documentation for the Form I-9 that requires re-verification when it expires, your employer will ask you to present something else to show that you continue to have permission to work in the United States. If you present a permanent resident card for the Form I-9 and the card expires, the employer should not ask you for another card or document. In other words, employers should not try to re-verify a green card. It's a type of document that is not re-verified when it expires. Regarding the Form I-9, an employer should never re-verify documents from List B, such as a driver's license, permanent resident cards, documents presented by U.S. citizens, or documents presented by U.S. nationals. As with hiring, workers have the right to choose the documents they wish to present for re-verification. If you present a document that requires re-verification when it expires, you can choose any document from List A or any document from List C. Workers do not need to present the same type of document they presented when they started the job. Employers must accept any valid document from List A or List C that the worker chooses to present. Employers do not need a List B document for re-verification because they're only re-verifying permission to work. The purpose of re-verification is not to re-verify the worker's identity. If an employer tries to tell you what type of documentation to show for the Form I-9, call IER for assistance. IER frequently receives questions about the Form I-9 on our hotline. For example, automatic extensions of employment authorization documents. Some non-citizens can continue to work even after the expiration date on their documents. This means that even if the document appears to have expired, it might still be valid. Other workers can get an extension for their documents if they submit a timely application for the renewal of the same and have a receipt indicating that they have already reapplied. There are several rules regarding automatic extensions. You can call the IER hotline if you have questions. Call us if an employer won't accept your automatic extension. Permanent resident cards or green cards might have some extensions as well. List B, number 2, is a broad category that covers many documents. The definition of a type B2 document is an identity card issued by a federal, state, or local government, agency, or body, provided it includes a photo or information such as name, date of birth, gender, height, eye color, and address of the person. Since it's not a specific document, the worker only needs to present a document that fits the parameters. Note that a photo is not required unless the employer uses E-Verify. Instead, the document could contain a physical description of the individual. For example, transportation boarding letters fit the parameters, or even a municipal library card with a photo or description of the person. There are many other non-traditional List B documents. List C number 7 is a broad category that also encompasses many documents. There are many documents that also fall into this broad category. For example, a certificate of naturalization or an asylee form I-94. Receipts for lost, damaged, or stolen documents. Workers are allowed to present receipts for lost, damaged, or stolen documents for the Form I-9. Generally, these receipts are valid for 90 days. At the end of that 90-day period, workers can present the type of acceptable document they wish to present. An MRIV is a machine-readable immigrant visa. The document is normally valid for 1 year after the person's arrival in the U.S. Employers must look at the date on the stamp and not the date on the visa to determine the expiration date. MRIVs are a List A document that require re-verification prior to stamp expiration. There are many kinds of Forms I-94. Some are useful for the Form I-9 and some are not. Employment Authorization Document Extensions. Some EADs are eligible for extensions. There are different kinds of extensions and the rules vary. For some EAD extensions, it's not necessary to show additional documentation. For other kinds of EAD extensions, it's necessary to show an I-797C receipt notice. I-9 Central and the Handbook for Employers have information about the different types of extensions to help an employer when an employee is showing their extended EAD, and employers and workers can call IER with questions. There are several types of Forms I-94. They vary both in appearance and utility for the Form I-9. The purpose of this slide is to point out that Forms I-9 can have different formats. One version is a card that the U.S. government gives to the individual. Another would be a printout that the person can access online. A Form I-94 can also be attached to a Form I-797. All of these versions are considered Forms I-94. Different categories of non-citizen workers might have a Form I-94, and depending on the type of the Form I-94, it might be useful for the Form I-9. Sometimes the worker will need to present another document together with the Form I-94. Let's highlight a few types of Forms I-94 along with their relationship to the Form I-9. There are several types of Forms I-94. Some are useful for the Form I-9 and some are not. As you can see, the Form I-94 can have different uses depending on the worker's immigration status. This slide is not an exhaustive list. There are many other types of Forms I-94. For example, an I-94 in a passport is a List A document for some workers. It should be noted that a Form I-94 does not need to be presented with a foreign passport when presented by lawful permanent residents or workers granted asylum or refugee status. Form I-9 rules can be complicated for employers and workers. Please call us with questions. If a worker has enough documentation to complete the Form I-9, the worker can be hired and start work for pay, even if they're still waiting to receive their Social Security number. The Social Security Administration, the Internal Revenue Service, the Department of Homeland Security's U.S. Citizenship and Immigration Services, and the Equal Employment Opportunity Commission offer guidance to employers on this topic. Call IER if you have authorization to work in the United States, but experience obstacles to employment, or if an employer refuses to pay you for work you have done due to the fact that you are waiting to receive your Social Security number. Some employers use a government program called E-Verify. E-Verify compares information found in various government databases to look for discrepancies. If a discrepancy is detected, the employer must inform you of the mismatch result and give you the opportunity to resolve the mismatch. E-Verify compares Form I-9 information with government records. IER does not administer E-Verify, but we do investigate discriminatory use of the program. If an employer uses E-Verify, the correct order of actions is to hire the worker, complete the Form I-9, and then enter the worker's information into E-Verify. Employers should not request specific documents for the Form I-9 or E-Verify. Normally, the result of a case in E-Verify is work authorized. Sometimes workers get a result called a tentative non-confirmation or a mismatch. A mismatch is not evidence that the worker is not authorized to work. If there is a mismatch result in E-Verify, the worker has 8 federal working days to contact the Department of Homeland Security or the Social Security Administration, depending on the instructions the employer gives the worker. Most mismatches are due to typos, so it's important to check that there aren't any mistakes. If there is a mistake, employers must close the old case in E-Verify and open a new one. If there is no mistake and the worker takes action, employers are not allowed to use the mismatch as a reason to fire or suspend the worker. If you receive a mismatch result and do not identify any mistakes on the Form I-9 or in the E-Verify case, the correct steps for the employer and worker are the following. The employer informs the worker of the mismatch with a notice of further action. The worker indicates whether they will take an action or not. If the worker takes action to resolve a mismatch, the employer submits the case in E-Verify and provides the worker with a referral date confirmation. The worker follows the instructions on the referral date confirmation to contact the Department of Homeland Security or the Social Security Administration, sometimes both. The worker has 8 federal working days to contact the Department of Homeland Security or the Social Security Administration, depending on the instructions received. If you decide to take action to resolve a mismatch, your employer may not suspend you, fire you, or take any other negative action against you based on the mismatch. Sometimes a work-authorized person receives a final non-confirmation result in error. Contact E-Verify at 1-888-464-4218 about a final non-confirmation if you think it is in error. The 4th type of prohibited discrimination is retaliation. People are protected from retaliation or intimidation for asserting rights under this law. Retaliation includes intimidation, threats, and coercion. Some examples are protections for people who file a complaint with IER, collaborate in an IER investigation, dispute actions that you think might be illegal under this law, call the IER hotline, or otherwise speak up for rights under the law IER enforces. IER investigates allegations of unlawful discrimination. Workers or their representatives can file discrimination complaints with IER, which we then investigate. IER also has the power to initiate independent investigations if there are reasonable grounds to believe that an employer has committed a violation. If IER does not find evidence of unlawful discrimination, we dismiss the complaint. When IER finds evidence of unlawful discrimination, we attempt to resolve the issue, typically through a settlement. If IER is unable to reach a settlement with an employer, we may file a complaint with an administrative law judge. When individuals file complaints with IER, they also have the right to file their own complaints with the administrative law judge, regardless of the outcome of the IER investigation. Possible remedies from a settlement agreement are as follows. The worker can be hired or rehired. The worker can receive back pay. The employer can undergo training to try to prevent future violations of the law. The government might monitor the employer to try to prevent future violations of the law. The employer can change policies that violated the law, and the employer might pay civil penalties to the federal government. If you want to file a discrimination complaint with IER, you can file it in any language. The complaint form is available in many languages. It must be submitted within 180 days. It can be submitted online, by regular mail, by email, or by fax. See the links here on the side. to find the IER complaint form. What are some reasons to call us? You can call us, for example, with questions or problems about the Form I-9. Some examples would be working with your automatically extended employment authorization document, or EAD. If your employer asks you for a new permanent resident card for Form I-9 reverification. If your employer won't accept your acceptable documentation because they want something different. Questions about E-Verify. Questions about Social Security number requirements for employment, U.S. citizenship hiring requirements, the process of getting or renewing your driver's license or state ID, and with issues applying for a badge at work, such as when working in airports. You can call us at 1-800-255-7688. The IER hotline is available Monday through Friday from 9 a.m. to 5 p.m. Eastern Time. Calls can be anonymous, and we offer interpretation services. We're here to serve you. If you have the right to work, don't let anyone take it away. Thank you for listening.